Welcome to Inside IR, a podcast series by Herbert Smith Freehills Kramer that explores the latest developments in Australian industrial relations law and practice. Hello and welcome to Inside IR, the Australian Industrial Relations podcast, the series that arms HR, IR and legal professionals with the latest industrial relations thinking. Today on Inside IR, we'll be covering the topic of gender undervaluation of wages and the impact that this could have on award minimum rates in Australia. My name is Rohan Doyle. I'm a partner in the industrial relations practice at Herbert Smith Freehills Kramer. And joining me today is fellow Melbourne-based partner and colleague and long-suffering Carlton supporter, Nick Ogilvie. Welcome, Nick.
Thanks, Ryan. I don't think I've got time to talk about my suffering or the right classification rating, but we'll do that with another podcast.
No, we should start our own Carlton podcast, but we'll get there one day. Now, Nick, one of our listeners might not know about you. One of the things they might not know about you is that you are an expert on the topic of gender-based undervaluation of wages, and you're engaged on a number of matters dealing with that topic at the moment. So we're going to explore that knowledge today and share that with our listeners, and we're going to do that by covering 4 different aspects. First, we're going to ask you, what is gender-based undervaluation of wages and what is the Federal Commission doing with minimum award rates of pay? Second, we'll then move to what precedent we've seen in this space so far and what cases are currently in progress. Third, we'll move to what industries might be scrutinised next as part of the gender undervaluation assessment. And then finally, we'll look at what are the implications for employers in this space and what should they be thinking about next. So, Nico, let's get straight into it. You're well across this topic, working on matters relating to it at the moment. What is gender-based undervaluation of wages and what is the Federal Commission doing with minimum award rates?
So I suppose to start with what it is first. Gender-based undervaluation really refers to the historic and systemic undervaluation of work done by certain occupations, predominantly female occupations, because of outdated assumptions about the value of that work, so the value of soft skills and caring skills. The process the Commission has adopted is really, it's a bit different from what we normally do in our practice. The focus is not on the employer level bargaining, it's more old school industrial relations, where it's about dealing with occupation level and sector level minimum award rates of pay. And from that's what I find fascinating. So although it's sort of occurring in the background, it can have implications for employers going forward.
Okay. And when did this start, Nico? There's been a lot of focus in Fair Work Commission award reviews of recent times about gender undervaluation. Why is that the case? When did that start?
Really, there's always been a requirement for the Commission exercising its functions to look at gender equality in terms of the way it performs its functions. Following a range of decisions in teachers industry and others, the legislation actually changed with the Secure Jobs Better Pay Act and actually put into the requirements when the Commission is exercising its modern awards function and its minimum wages objectives to positively look at eliminating gender-based undervaluation and ensuring that there is same pay for comparable work. And really looking at positively taking steps to ensure that the gender pay gap in the different ways that it's measured is closed.
And so, I mean, as you've pointed out, there's always been mechanisms to address disparity in those matters, but they've been bolstered through the Secure Jobs Better Pay reforms. And as you say, Nico, a mandatory consideration in meeting the modern awards objective in setting rates of pay. So what were the first few decisions that have confronted this issue, and what are the industries and occupations that have been dealt with?
I think if we start with the first decision that really addressed it directly was the annual wage review decision from 2022-23. So 2023 annual wage review decision. And what that highlighted is a range of earlier cases that have focused on work value for different occupations within awards. And what became apparent pretty quickly is that if you go back to 2009 when the modern awards were basically created, there was a process for those who were involved of simplifying and modernising thousands of awards in the federal system and providing appropriately set minimum rates of pay for various classifications. A lot of that was done by aligning classifications and awards to what was called the medals framework, so the C10 medals framework. What was highlighted in the previous decisions and then focused on by the 2023 annual wage review decision was that process wasn't always done properly. That there were assumptions made about the value of work, particularly where there was softer skills or what's called invisible skills for for nurses, for teachers, for people involved in care type occupations that weren't properly valued against the equivalent for a male-predominated occupation in the metals industry. So that they were improperly set against the C10 as a base rate, and then the relativities flowed from there. The other thing that became apparent was that a lot of these occupations have become more and more education requirements. So there's a lot more jobs that are more complicated to do, require a lot more learning involved to maintain that role, to get the role. So there's a range of awards that have for example, a degree-based classification structure for professional classifications, where you're required to have a university degree, that don't line up to the C10 metals rate either. So they're lower than the C10 metals rate for the C1 metals rate for the equivalent classification. So really the annual wage review decision in 2023 started that process. Right. They then commissioned some research to be done for the commission on identifying industries where that was a problem and identifying where there was indicia of where there might be gender-based undervaluation and setting those wage rates. The next step, I think, was the following year, the 2024 annual wage review decision, which basically took submissions from the ACTU, from employers, from employer groups, about what awards should be given priority. So taking the research the Commission had done, so everyone's on the same page, what awards need to be looked at to make sure that this wasn't a phenomenon going across the whole of these industries. And they picked 5 awards. So they picked, and that's what became the priority awards process. So the 5 priority awards included the Pharmacy Award and the Social Community Health Services Award and the Health Professionals Award. So there's 5 awards picked. A range of classifications or occupations within those awards were predominantly, they were female, more than 60% female dominated employees.
Right. And that's where the process started. Obviously, a huge task, Nico. And as we've said, it's really been triggered and bolstered by the Secure Jobs Better Pay amendments to objects in the Act and the Modern Awards objective.
The Commission thought they changed the legislation as a positive requirement for them to do something. So there's some commentary in the decisions that say we can't leave this to individual parties to make applications going forwards. This is something that needs to be part of the annual wage review process, or if it's not, it needs to be part of some other separate process of the Commission. So that's therefore we got the annual wage review looking at it, but also priority awards looking at it as well.
Yeah. And so therefore, obviously, an area to watch because it is constantly changing and developing, and we're moving into new industries and occupations. Just to dig a little bit deeper on that, Nico, what precedent have we seen in this space so far, and what cases are currently in progress?
Yeah, so there's a couple of outside the annual wage review decision, which are quite detailed in terms of the principles. At the same time, the 2023 decision was implementing research. Proceedings commenced to vary 3 awards in the aged care sector. So we've had basically not a gender undervaluation, but a work value review of classifications in the aged care sector, supported by the government. So you had the aged care award, the social community services award, plus the nurses award, and classifications within that was all focused on, I think the proceedings went for 2 or 3 years. And the stage 3, there was 3 stages, and the stage 3 decision was handed down later last year. And that really set some principles for the Commission in how they identify the awards to look at and the process of what they should be looking at during that evaluation, and making sure that it's consistent. So what we've seen is that the annual wage review decisions build on each other, and they build on the aged care case, and then they build on decisions that have arisen from that case as well.
Yeah. And what are the outcomes that we've seen so far from some of those assessments?
The priority awards decision, which was handed down in April this year, focused. The Pharmacy Award was awarded pretty significant increases to the minimum rates. So you're talking about safety net minimum rates of pay, which range from sort of 2 or 3% increase for a classification, right up to a 30% increase. So in aged 30% increase. So in aged care, for example, the interim decision offered 15% flat to everybody, and then they built from that. So as a minimum of 15% aged care. Now that's different, slightly different circumstances to other sectors because it was federal government funded. So the government promised to fund those increases. So now you've got, for example, the Nurses Award. So the nurses were involved in aged care, but only in terms of the nurses in aged care. So the Nurses Award also covers obviously private nurses. That process is ongoing, and they have to then work out how to implement the findings of the aged care nurses onto their own rates of pay without the backing of government funding.
Yeah, and that's, of course, a live case, and there'll be some debate about the extent of wage increases, if any. How much does other factors like capacity to pay impact on the employers and their operations in the industry weigh into this assessment, Nico? Is that a relevant factor?
as I said, this is slightly different from the normal employer union bargaining type dynamic. We're talking about things at an occupational level and a sector level, and we're talking about objectives of the Act that the Commission is required to do or to take into account when setting appropriate minimum rates of pay and setting appropriate awards that are fair and relevant to the society. The capacity to pay is one element of the things that the Commission must take into account. There's not many elements that apply to employers, but one the things they are required to consider is impact on productivity, impact on the economy, viability of the business. So one of the ways that an employer can resist to some extent these increases that might arise. So you can imagine that our clients don't want suddenly you have a 15% pay rise for the minimum rates of pay if they're award covered. We'll get to the agreements in a minute, but one of the ways is to say that, look, this is really going to impact on our ability to employ people and impact on our ongoing viability. But that's a difficult evidentiary task in the context of a sector-wide or an industry-wide application. So using nurses, for example, like private hospitals, there's a wide range of private hospitals around. Some of them are very profitable. Some of them operate on enterprise bargaining agreements. Others are not as much smaller and operate on a ward level. And to have evidence around specific impacts of increases on viability, it's actually not easy to generate that evidence. And for example, in the aged care decision, the Commission basically dismissed that as an important factor because there was going to be funding from the Commonwealth.
Yeah. And I mean, of course, to the extent there's gender-based undervaluation of wages, they should be addressed. But it does raise an issue that we're seeing in other industrial relations contexts as well, and that is where an industry, occupation, employer, whichever level, is being hit overnight with a significant uplift in the rates of pay that they're required to pay to their workers, that obviously has some impacts. And businesses and to some extent industries have been set in terms of the way they operate based on a certain understanding of the cost base.
That's right.
And so sudden shifts in those things, it's hard to argue to the contrary, are going to have impacts. To what extent is the Fair Work Commission taking those matters into account so far? And are they looking at things like transition arrangements to I suppose, increase the amount of time that employers have to implement these changes?
You're exactly right, because a lot of businesses, whether big or small, will be budgeting, and they'll look at 2 years ahead, 3 years ahead, and so suddenly if you use a really rough example, a 25% increase to their cost base in one type of employee, that can have pretty significant effects on them and their viability going forwards. One of the major sort of sticking points for employers is about what they call a phasing in process. So the default position from the Commission is that if they make a determination to increase award rates of pay, then that applies from the 1st of July after the decision is made. And we see that with the annual wage review decisions, where they're made just before the 1st of July and they impact from 1st of July onwards. That's the presumption. That's the automatic position under the Act. There is a mechanism that the Commission can phase in those increases or change it to the classification structure over a 1 year, 2 year, 3 year period. And we've seen in aged care and in the priority awards that the Commission's adopting a sort of 2 year, 3 year phase-in period for some of those award rates of pay. There are other examples in similar circumstances where, for example, the community sector got an 8 year phase-in period, but that's very different in terms of the profile of the employers, because they're often not for profit, often low levels of HR and payroll assistance. They rely on government funding basically to survive, and so there was at least a consensus that they needed a longer period. But you're looking at businesses, for some, not any specific examples, but businesses that are already struggling in terms of their revenue, have a sudden increase in cost base on top of the annual wage review decision. So this is in excess of the annual wage. For example, this year was a 3.5% increase to minimum rates of pay. So you add a 15% or a 25% increase to that for certain rates of pay, and you can suddenly see that could cause problems for many employers.
That's potentially on top of course, other reforms that are driving increases to rates, like same job, same pay, increased leverage in bargaining, those types of things as well. So it'll be interesting to watch. Just before we move on to the next point, Nico, so just in terms of assessing where we're at now, you've mentioned in terms of live cases, nurses in private hospitals.
Yep.
What other matters are live at the moment and still yet to be determined?
So it's interesting that the annual wage review decision took, again, submissions from the ACTU and others about what wards should be given priority. But in the back of your mind, you've got to realise that this is not just a commission process. Applications can also be brought by unions themselves. So the full bench in the annual wage review decision basically determined that they had a lot on their plate, and they took submissions from the ACT and others about which awards and which occupations within those awards should be given priority. Not surprisingly, there was no submissions from employer groups other than the ARG about which awards should be given priority. I don't think anyone wanted to put their hand up and volunteer themselves. And the ARG's position was, I think, in short, that you shouldn't give any awards priority, but we should have a forum and some sort of discussion between
More holistic
employer groups and unions about what should be the priority. The Commission basically outlined its program for the rest of the year, and it's got a lot on its plate. It's got the last four awards from the priority awards to deal with. It's got the Nurses Award case to deal with. It's got variations to the Clerks Award to deal with working from home. It's got variations to the junior rates of pay under the Retail Award. And that's basically said they've kept their book busy until the 2026 wage review decision next year. What they did do was say there's an easy way to shortcut some of these issues, and one of them is where there's a misalignment between as we talked about, the professional rates, professional classifications, where there's a degree qualification or something equivalent that you need to qualify for that classification structure. And there are a lot of awards that has been set against been misaligned against the medals framework, the CC1 medals framework. So what they've done is they've identified, I think, 20 or so awards, which were attached to the back of the 2025 decision. And said, we're going to look at these and make sure that the classifications that are degree qualified are properly align with the C1 structure. And that's not necessarily gender-based. I mean, the first one on the list is the Black Coal Mining Award, which I would presume is not predominantly female workforce. So there's a range of awards there. There's also an application, the FAAA, the Flight Attendants Association, on the last two occasions of the annual wage review actually made an application for their award, the Aircraft Cabin Crew Award, to be given priority. And the Commission actually did some research for them in terms of how the award rates were set, but then ultimately determined that they didn't identify that as a priority award because the FAAA made their own application. So there have been other unions that are threatening those types of applications, but at the moment there's nurses in private hospitals going, the rest of the priority awards going, in the Aircraft Cabin Crew Award going.
It's a good summary, Nico, because what it shows is, I think in the early part of this process, you have a lot of people thinking, well, it's really about the care economy. And for those not in that industry, the sense was maybe I don't have to worry about this, but that's not right.
That's right.
It is already branching out well beyond care economy, healthcare and the like. And it is something that, almost all employers are well advised to keep an eye on. Beyond those that you've mentioned, Nico, what industries might be scrutinised for gender undervaluation next? Do you have a sense?
Yeah, you get a good sense from the submissions that were put by the ACT or the annual wage review decisions, and based on the research that was done initially in the stage one and the 2023 decision. There's a number of awards, for example, in retail assistants, for example, predominantly female employees. I think it's figures like 85% are female employees. Hair and beauty, veterinary services, and even legal services are identified as potentially awards with classifications of occupations in them that would start with the criteria that they're more than 60% female and have a reliance on awards with minimum rates of pay, and potentially have some of the indicia that said that those awards rates, when they were originally set back in 2009, 2010, weren't done properly. So that's I think in terms of, I'm surprised from a personal level the retail award hasn't been singled out. But I think because there's already applications to vary the retail award in other contexts, that's been put to the one side. But having said that, the Commission's moving very quickly through these processes. Each decision of the annual wage review relies on the previous decision and relies on the principles put forward by the previous cases. And the presumption that if there is a misalignment when the award rates were originally set to the medals C10 framework, if there's a misalignment, it's very hard to displace that presumption. That's because that the work was undervalued, that the value of the skills that were involved in the predominantly female type work, female dominated environments, wasn't properly valued. So it's very hard to displace that presumption.
Yeah, right. And I mean, from the decisions we've had to date, the submissions you've referred to, Nico, strikes me, and tell me if you've got a different view, it strikes me that most of our clients should be in a position to risk assess where their business, their jobs, their roles, their classifications sit in terms of the likelihood of being impacted by this process. Do you agree with that?
I think that's right. The only issue is you need to have a really good understanding of where the award rates in the award came from. So if we go back to the start, the Commission's got an obligation to set a relevant and fair minimum safety net rates of pay. And that was done in the award modernisation process pretty quickly. And if you think about thousands of awards being suddenly reduced down to 120 more simplified awards, the way those minimum rates were set was not always done with a proper work valuation assessment done. There's no independent assessment of what the value of that work was. And if it was done, it's probably based on assumptions that the value of the work for the predominantly female occupations wasn't as valuable as the male occupations. Yeah. So that's if you've got a grasp of that, that's a good start. Then it's understanding of, okay, where do we sit against the modern award? Are we paying at modern award rates of pay, where therefore we'd be exposed? Are we paying above it in terms of just under contract, or are we paying above it in terms of enterprise agreements?
Yeah. And so, I mean, it would be, I think, good practice for our IR practitioner listeners to have a view, particularly if you're paying at or close to award rates of pay in an industry or in occupations that perhaps have traditionally had a female-dominated workforce.
That's right.
This is something that should be looked at. It's something that should be monitored, and perhaps go as far as to say that plans should be in place for what might need to be done in the event there is that very significant short-term uplift in wages. Just like, the same approach really should be taken in the higher risk industries and sectors that might be exposed to same job, same pay orders and the like. Very important to, have a forward plan for those things. But I think that's a handy segue, Nick, to the fourth and final part of our discussion, and that is, what are the implications for employers here, and what else should they be thinking about?
Talked about at the start that this sort of it appears to be happening in the background, and you might think, well, we don't pay award rates pay. We've got an EBA that sits on top of it. It is going to be relevant for your boot assessments for your new agreements. It's going to be relevant for setting expectations in bargaining. So if there's I'll use cabin crew for example. So if there's a flight attendant's application to vary the underlying rates of pay in the award, the union's not going to wait until those determinations are made. They're going to push ahead for increases that will cover those off what they perceive to be the potential increases. And even if you think you can absorb for most of your rates of pay, there might be some lower, if you're, say for example, your lower classification levels are closer to the award than others, there might be a scenario where it creeps your minimum rate of pay, which required to pay creeps above that minimum EBA rates, and which you're entitled to pay, you're required to pay that rate of pay as your minimum wage under the agreement anyway. And even from that flows on, if you say, for example, you increase your level 1, it throws out the relativities with level 2, level 3, level 4. So it might have a flow-on effect. Even if your higher classification structure well above the award, it might flow-on effect to them as well.
Yeah, and I think that was one of the first things I thought about as well, Nico. For those who do have agreements, really important, there's an appreciation that this could impact your base rate of pay obligation and require you to uplift rates, even though you have an agreement in place.
That's right.
Yeah.
And it's complicated to try and estimate what that outcome might be, because the outcomes from the determination from the commission are not straightforward. So use nurses in aged care, for example. There's 7 different classifications or 8 different classifications. Each had slightly different increases in rates of pay, and what the process is quite a simple process that I think is being built on by each of the decisions. Is there's 2 benchmark positions. One's a caring skills benchmark, which is set in terms of under the aged care decision for nurses. So you say you're predominantly exercising skills that are caring, so that's the benchmark for any caring type roles. And then there's the C10 professional classification benchmark, which is C1A. So you've got to make sure your professional classification, and once they're set, the relativities within the award flow from that. So you might get a 10% increase to your benchmark rate, which then you have to make sure that the relativities within that award flow equally from that set benchmark rate, and then you've got to apply that to your minimum rates in your agreement. So it's difficult to predict what it's going to be going forward unless you've done that analysis.
Yeah, thanks, Nico. I mean, it goes to show that this is one of many things that are happening at the moment in the IR space that can have a really material impact on cost bases. And it really is incumbent on all of us, particularly IR practitioners, to monitor what's going on here. And I mean, there's a relatively easy way to do that, Nico. You can subscribe to the Fair Work Commission website and get updates on the award.
And there's a lot of information on the Fair Work Commission website, which has been really useful in terms of parties in the proceedings.
Yeah.
But I think the point to make, as I've made before, is that this is not going away. The Commission has got a head of steam on this, and they're going to be pushing through these applications and pushing parties to agree to the increases by consent, rather than having to do 3-week hearing in terms of work value. And it's not a space that employers want to be in, arguing that the value of the work their employees do is not as much as they say it is. It's not a good look for employers either.
Thanks for your insights on this topic, Nico. I know that any of our clients who have questions on this area will no doubt pick up the phone and give you a call, given how well you are across it. So thanks for sharing those today. And thanks to our listeners and watchers for joining us. If you've got any feedback for us on Inside IR, please let us know. Feel free to comment, direct message, or send us an email to insideir@hsfkramer.com. Otherwise, we look forward to seeing you on our next episode of Inside IR.